5 seconds to go. Start. Merely because the contractor had accepted final bill, it cannot be deprived of its right to claim damages if it had incurred additional amount and able to prove same by acceptable merits. The appellant firm, a partnership firm registered under the Indian Partnership Act, is carrying on the business of construction of roads, buildings, dams, etc., mostly in Saurashtra and also in other parts of the state of Gujarat. In response to the invitation of tender by the state government for construction of Faljar Dam 2 in Jamnagar district, the appellant firm quoted and offered to construct the same for the quotation, specifications and design of the dam, wide covering letter dated 5th June 1970. In the said letter, the appellant firm also offered that they would give rebate of 3/4% provided the final bill be paid within 3 months from the date of completion of the work. The offer of the appellant being the lowest amongst other parties, R was accepted by the state government with the clause that the construction work was to be completed within a period of 24 months from the works order dated 7 September 1970, which was subsequently clarified that the period of 24 months was to be commenced from the date of commencement of work, that is 29th November 1970. During execution of the said work, the executive engineer who was in charge of the project made certain additions, alterations, and variations in respect of certain items of work and directed the appellants to carry out additional and alteration work as specified in writing from time to time. The final decision as to the alteration in respect of certain items of work and in respect of the depth of foundation, which is known as cut-off trenches (COT), took long time, with the result that the firm was required to attend the larger quantity of work and thus entitled for extra payment for the additional work. As per the works contract, the firm was not paid the running bill within the specified time and therefore suffered loss. On 16 July 1976, the firm lodged a consolidated statement of their claims for the additional or altered works, etc., to the executive engineer. As there was no response, the firm served a statutory notice dated 4th January 1977 under Section 80 of the Code of Civil Procedure, hereinafter referred to as the Code. Again, on 24th March 1977, after getting no reply, the firm filed civil suit number 30 of 1977 on the file of the Civil Judge Senior Division Jamnagar, praying for a decree of the aggregate amount of rupees 3,66,538 and 5 paise, with running interest at the rate of 9% per annum from the date of final bill till the date of suit and at the rate which may be awarded by the court from the date of suit till payment. Wide order dated 14 December 1982, the civil judge allowed the suit and passed a decree for a sum of rupees 2,27,758 with proportionate costs together with interest at the rate of 6% per annum from the date of suit till realization. Being aggrieved by the said judgment and decree, the state government filed first appeal number 2038 of 1983 before the High Court of Gujarat at Ahmedabad. The division bench of the High Court vide its order dated 7th October 2002, AIR 2003 Gujarat 185, allowed the appeal of the state government and dismissed the suit of the appellant firm, and also directed that the decretal amount deposited by the state government and as permitted to be withdrawn by the firm should be refunded within a period of 4 months from the date of the judgment. Being aggrieved by the said judgment, the appellant firm has filed this appeal by way of special leave petition before the court. It was held by the Supreme Court that the relevant issues framed, ultimate discussion and conclusion at by trial court were correct, and the plaintiff was entitled to the said amount as granted by the trial court. Stop.